Oh, I'm tiny. Welcome to Victory Monday here at Defense Diaries. I am your host, Bob Mata, and this is our new coverage, the continuing coverage, kind of the Karen Read civil trial. So it's really starting to get rolling now. Today's a motion hearing in the case, and it is going to be interesting. I think there's a few things going on today. I think there's an actual motion that's being argued today. I think this is the day that Alan Jackson and Liza Little are going to enter their appearance officially into the case. So it should be interesting. It should be interesting. If you saw my tweet, it's exactly how I feel. It's that scene from Godfather, I think part 3, where he says, just when I thought I was out, they pulled me back in. Yeah, it's basically that thing. So, but civil trials are different. They're interesting. They are not criminal trials. If you guys watched Depp versus Heard, that was a civil trial. It had a lot of the kind of the earmarks of a criminal trial, but it was civil. It was civil. And this will have the same thing. We'll hear an awful lot about about the criminal trial during the course of the civil trial, because obviously that's the underlying premise of the civil case. Wait a second here. Mike's trying to bring me down on Victory Monday. Not going to work, buddy. Not going to work. It's not going to work. I am in high spirits. I don't care what the Vikings are doing. I don't care what the Packers are doing, even though I did love that they lost yesterday. They like was the cherry on the top of the Sunday of awesomeness that was yesterday. It was me and the kids out at the game. Caleb looked phenomenal. I don't give a shit how bad Dallas's defense is. You play who you line up against. That's it. That's how that goes. So it was a great day. It's funny. Like, I'm an old man, but it's really, really weird how much the Bears and their failures or success actually affects me. So it's like but it does. And it had been a year since we won a home game. So, and Caleb looked phenomenal, and I'm really excited. And Ben Johnson, man, he's the truth. He is the truth. We finally got us a real head coach. So it's exciting. It's exciting, the potential to be competitive, to be an actual NFL football team. That concept is what's up. So what's up with you beautiful humans? What is the word on the street? Did y'all have a good weekend? I hope you did. Allie and I did. A lot of music this weekend. Well, I had more music than Allie. We went and saw Kingfish, which, if you're into the blues at all, you should know he's the new. He is the new. He's the up and comer. All the old head blues guys love him because he's going to keep blues alive. He's awesome. But our friend plays keys for him. We saw that at Park West, and that was a great night. It started out horrifically. in that I couldn't find. I let Allie and our friend out so they can go in, and I'm like, oh, I'll find a parking spot. And an hour later, there was no Spot Hero. There was nothing around that. I could not find a parking spot. I was so pissed off. It like after being an hour late into the show, I'm texting Allie. I'm like, you know what? I'm good. I'm ready to go. And so finally, my whining and sniveling, they agreed to allow me to park in this alley that was right next door to Park West. Dude, that was frustrating, but it ended up being a great night. So, and then Saturday, I saw the Goose over at the Salt Shed, which is our new crown jewel. So, yeah, it was a good weekend. And then it all culminated with, oh, there she is, my beautiful and brilliant co-host. What's up, girl?
Hey, babe. Hey, all. Yeah, so I woke up.
Yeah.
Down Chicago Bears.
I mean, I'll sing it. Don't make me sing it.
Touchdown, Bears.
Yeah. Oh, thank you, Mandy. Thank you. See, what a gal. What a gal. All the girls worked on this, putting this live together yesterday because they're amazing. And I wasn't going to have to worry about it when I got home. So that was a wonderful gift. It was another great little cherry on top that I didn't have to do that. I was exhausted by the time I got home.
I mean, it was quite a weekend. And I mean, I just woke up. I woke up early, stayed downstairs and just fell asleep on the couch and woke up like 4 minutes ago. So oops. I'm like, all right, I get everything ready, let Bob sleep. But it was a very long weekend, especially for Bobby.
Yeah.
Started out on Friday, got our blues on, saw a very good friend of ours, Deshaun Alexander, aka D Vibes, who does have his own band, Watermelon
Amazing
Funk,
player. Yeah.
but he was playing the keys for Kingfish.
Oh shit! Hold on. I'm pulling it
starting?
up.
Only fan?
No,
Oh, it's not the same courtroom.
It's only Jackson. It's Action Jackson.
It's Action Jackson. So then we were out late night Friday. Oh, it started early?
Counsel, I asked the question that you asked, Counsel. He would like to do status first, then the Rule 12s, but he also said to me if you could check your calendars for trial date. All right. Ms. Crockett, are we good to go? You let us know we're ready.
Oh, that's the bailiff. They're like letting them know what they're. Right. So we were out late on Friday night. Then Bob got up early, met a friend of ours in the city to go see Goose. He's playing in Chicago. And woke up bright and early, took all the kids except our oldest to the Bears game. So I am so thankful that the Bears finally won. I really had no idea how pathetic it really was. Bob told me this morning this was the first time he won a home game for a year. Like, what? Kind of pathetic. The power of the Mata family. There's the OC family. I'm thinking when Bob gets back on, he's got to, if this is on boost, he's got to. I'm just, if it stays this loud, we might want to turn the boost off.
I mean, and not hear all the hot mic shit.
I mean, that's true. I mean, if somebody like farts in there, we're all going to hear it.
Like Mr. Woke. Isn't that Mr. Woke right there?
Good afternoon, folks. Good afternoon,
Your Honor. Good afternoon. All before the court is 2483 CV 692. This is the case of Paul O'Keefe and Alia versus C&C Hospitality, LLC, DBA, CF McCarthy. That Alia case is called for status and for Rule 12 motions. Counsel, please introduce yourself for the record, beginning with Plaintiffs' Counsel. And if you could state the party you represent as well. Thank you.
Good afternoon, Your Honor. Attorney Mark Diller on behalf of the plaintiffs.
Good afternoon. Good afternoon, Your Honor. Dan Buck on behalf of the plaintiffs.
Okay, good afternoon.
Good afternoon. Good afternoon, Your Honor. Damon Seligson on behalf of the defendant, Karen Reed.
Okay, good afternoon.
Good afternoon, Your Honor. Charles Waters for defendant Karen Reed.
Good afternoon, Your Honor. Alan Jackson on behalf of Ms. Reed.
Good afternoon.
Good afternoon, Your Honor. Aaron Rosenberg also on behalf of Ms. Reed.
Good afternoon.
Good afternoon, Your Honor. William Keppel on behalf of Karen Reed.
Wait, where's McCarthy's lawyer?
Good afternoon, Your Honor. Christopher George on behalf of the defendant, Karen Reed.
Oh my gosh.
Good afternoon, Your Honor. Marissa Palladini on behalf of Karen Reed.
Good afternoon.
Good afternoon, Your Honor. David Hassett on behalf of Waterfall Bar and Grill.
Okay. I'm sorry, did you say the waterfall?
Waterfall, yes, Your Honor.
Got it.
Good afternoon, Your Honor.
Karen Reed also on behalf of Waterfall Bar and Grill.
Oh, the waterfall. Not
Good afternoon.
Good afternoon, Your Honor. Looking Rose on behalf of the defendant, CF McCarthy.
Oh, there you go.
Good afternoon. Okay, that's all the counselors. Good afternoon, folks, and welcome everyone to the event for this afternoon. When I was assigned this case last spring, the first thing I wanted to do was try to get a sense of where we all are going to fill in our tracking order and get a sense of what direction this case is going. And in the meantime, it looks like there was a motion to dismiss filed by the defendant. So what I would like to do is go through some of the procedural issues that you see in the case for now. We can talk about tracking order. I do think that it's important to get a trial date established at this point, like we would do with any kind of a wrongful death tort action. So to that end, we'll start with the plaintiff. What do you see as procedural issues? I'd like to get an update on discovery and how that's all going. Counsel? And then we'll get into the motions to dismiss as a substantive issue. I know there's a lot of people here that want to see what the case is all about, but I think it's more important at least to get an idea procedurally where you stand. Understood, Your Honor. Plaintiff has served all of the defendants with discovery. All of the defendants are currently late with regard to producing discovery. We have not received any as of yet, or minimal. We have started to get some of the documents from the DA's office, though we are is significantly deficient at this point. We're still waiting for the records to come in. So we undertook with the stay that we weren't able to get any information, and the DA's office wasn't turning anything over while the criminal matter was pending. So we're still trying to get all the documentation in. Okay, but just if I can follow up on that, the stay that was issued, Judge White had issued one back in maybe the fall. I had issued one when the criminal trial was ongoing. That was sort of a self-defining 60-day or whichever comes first. So that should be pretty much in the rearview mirror for now, right? I recognize that, Your Honor. Right. So when the stay was lifted, all discovery was served on the parties or thereabouts. When you say discovery, we're talking about depositions, documents, notices of depositions, or no? Only one deposition has been noticed, and it's been tabled because we don't have any documents at this stage. I see. Okay. So it's really the paper discovery that you're looking for. And when you say the DA's office, that obviously is not the defendants. That's going in a different direction, but you're pursuing that sort of on your own? Right, but we've also, I anticipate that the defendants have all the same data that was exchanged during the criminal matter, to which we haven't ever received. So we have requested that both from the defendant, and we've requested it from the DA's office. Okay. It is coming in from the DA's office. in parts, and I anticipate we should have it all within the next 21 days, is my guess.
Okay. All right, procedural issues from the defendants. We can start with you, Attorney Seligson.
Thank you, Your Honor. As we're anticipating the status of this case, it's important to inform the court that from Ms. Reed's perspective, we have affirmative claims that we intend to bring on her behalf. Those claims stem from the same facts that are at issue in this case. Those claims, Your Honor, are against parties that are not in the litigation at this point, including the Massachusetts State Police.
Wow.
Lieutenant Brian Tully in his personal capacity.
Wow.
Sergeant Yuri Buchanan in his personal capacity.
Nice.
Michael Proctor. Those claims would be in the nature of violations of Karen Reed's civil rights and conspiracy. The claims against the Massachusetts State Police would be negligent training, supervision, and retention of Massachusetts State Police troopers. We also intend, Your Honor, to bring claims, affirmative claims, against Brian Albert, Nicole Albert, Matthew McCabe, Jennifer McCabe, and Brian Higgins, who were the occupants of 34 Fairview Road in Canton on the night in question. Those claims will be in the nature of civil conspiracy, violation of Karen Reed's civil rights, and then a claim against the town of Canton through its police department for negligent failure to secure the garage in the Sally Port. We asking the court's permission to bring those claims in this case because they do arise out of the same nucleus of operative facts. In order for us to fairly defend Ms. Reed in this case, those claims, those parties need to be asserted in this case. What we'd like to ask the court's indulgence for is we have a proposal of how to bring those claims in, given the voluminous nature of this case. That would be 10 additional parties coming in. To do that, we would be alleging that the individuals in the House diverted attention away from themselves towards Ms. Reed, that law enforcement then acting on that diverted attention away from her, because the people in the House were either police or police adjacent who were socially and personally connected. Then they collectively conspired to ensure that what happened in the House was not explored and investigated. And instead, Ms. Reed was wrongfully targeted, maliciously prosecuted, made to face 2 criminal trials for the death of John O'Keefe, and is now facing allegations of wrongful death, all stemming from the same claims. How do we synthesize the process to bring these claims and parties in? What we're asking the court to consider,
I could listen to this guy talk forever.
For us, at the time we file her answer to the complaint.
Sorry. I could listen to him talk forever.
Yeah, I'm trying to figure out. He sounds.
Somebody said South African.
That's what I was going to say. He sounds South African. He's got like kind of that lower key British accent, but which is exactly what it sounds like for South Africaners. So yeah, he's. I wonder if he's lead counsel.
He must be. He opened his mouth up. Shut up, Bob, and let him talk. He opened his mouth up first. He's definitely lead counsel, whether they call themselves that or not. He is the face of the case because he's the first one to speak on just where everything stands, period. So in my mind, that makes him lead counsel.
Yeah, me too.
Is for us, at the time we file her answer to the complaint, we've got some claims that we're asking to be dismissed. Regardless of how the court decides those, we still have to file an answer on her behalf. Our suggestion would be to file those claims against those parties in the same pleading.
It's supposed to be like that.
Serve all of those new parties with that complaint. Allow them 30 days, not the normal 20 days, to respond so the court can have one hearing on whether some may bring dispositive motions, some may file general answers, so that we can then decide how and who is in the case and proceed forward. So I bring that to the court's attention And I'm happy to brief it so that Mr. Diller can have an
Well,
opportunity.
at a minimum, you're going to do that. I'm envisioning what the plaintiffs are going to say to this rather extraordinary process, but go ahead.
But that would be, otherwise it's going to be in a very unwieldy, delay-inducing process, and we're not looking to do that. This accounts for trying to conserve judicial resources, trying to have a streamlined approach, at the same time making sure that all the claims and all the parties are in this case. The alternative would be for us to file a separate action on Ms. Reed's behalf, alleging these claims, and then move to consolidate immediately with this case, which Your Honor has broad discretion to allow. The point being, the claims should be in this case. They all arrive out of the same facts. They're not separate. And that's essentially what we'd like to do. We'd like to brief that, Your Honor, and have the plaintiffs respond and then proceed from there.
Okay.
And all those
let's
issues
hear
are
it
going
then
to be
from
involved
the
in this
Waterfall.
trial then, anyway.
Yes, Your
So,
Honor, we are
Yeah.
in the process of completing.
Same set of
discovery
circumstances.
responded to us from the plaintiff order extension until next month. We anticipate that will be completed then. We as well.
When you say an extension, this is an agreed to extension? Because the tracking order is what it is. We'll get to that in a little
Yes,
bit.
it's been agreed to, Your Honor.
Okay.
And then, Your Honor, we're looking at depositions, but we don't want to consider noticing depositions yet until a lot of the document requests have been answered and the subpoenas for keeper of records. We haven't seen any of the records. We're aware of them certainly from the criminal trial, but when there are a lot of records, as I understand it, that are still to be produced, so that we would then proceed with depositions as warranted in conjunction with counsel and obviously picking dates that work for all. But that's what we foresee in the immediate future, Your Honor.
All right, thank you.
there's
hear from
no
Steve McCarthy,
evidence the car hit the person, even for a civil case.
Touches on our discovery responses. The last leg of it is just collecting communications from employees in that incident, some of whom no longer work for Steve McCarthy's, but we anticipate having that included in the very short term and getting that over to my brothers.
Okay. All right, thank you. Let's hear from the plaintiffs then, in terms of the response to the procedural issue that was raised, in particular by Ms. Reed's counsel. Are you aware of the circumstances that they're seeking to join 10 additional defendants into this action?
Absolutely not, Your
It's the
Honor.
first notice you've gotten?
Of course, I would
Not how the
expect
court
that.
system likes this stuff to work, folks.
Right, I would expect the courtesy of a meet and confer to at least let me know. Obviously, they can choose not to do so. That's their prerogative, but I certainly would have liked to have been made aware. Section 1983 actions, I believe, Your Honor, would have to go up through the federal court. We're not seeking to have this case removed in the federal court. We started it in the state court. We're intending to move forward in the state court. We would like to have a state court, Plymouth jury decide this case. So to the extent that my brothers and sisters and all of those who are involved believe that they have other legal rights and they want to pursue other legal theories, that's their prerogative to do so. When it comes to interfering with our opportunity and right to justice, we're not looking to sideline that, Your Honor.
All right, any response, counsel?
Thank you, Your Honor. We are asking for permission to serve a motion to advance this procedural proposal. So Mr. Diller is not being
Don't tell your
surprised by
answer.
the argument that we're going to present to the court. He will have an opportunity to respond. There's no requirement that civil rights claims be brought in federal court. In fact,
True.
this court has jurisdiction over those claims. They all stem from the same facts, Your Honor. In the plaintiff's complaint, there are allegations that we need those parties to defend against. This is not just a wrongful death action. Our narrative of what took
But it
place.
is, though. It's the plaintiffs. Well, just hear me out for a second. And when you say that it's not just a wrongful death, that's what the plaintiffs have alleged. The defendants have filed motions to dismiss portions of those. So with this, at its essence, is a wrongful death action being brought by the plaintiffs, right? So what you're seeking to do is to be allowed to amend these proceedings and to effectively bring in 10 other defendants for the claims that the defendants have against those third parties that aren't noticed here, right? So you've got to procedurally give them notice as well as the plaintiffs notice of this event before it goes to any adjudication by the court.
And that's what we've built into this proposal, which is trying to streamline that process, not depriving them, the new parties, of the opportunity to argue both the procedure as well as the substance. And we're suggesting, instead of serving party X with a third party motion for a complaint, then that party opposes it, then the court rules, then that party perhaps is brought into the case and then brings another motion to dismiss substantively. We're not seeking to...
Isn't that what the rule requires?
The rule does require that, but the court has discretion to consider the streamlined approach. And we'd like to brief that for Your Honor, but we're raising it at the status conference so that, because we are scheduling deadlines and events out into the future, we'd like to at least have the opportunity to advance that argument for the court and allow Mr. Diller to respond to it. And then we will act accordingly. That's the purpose of the disclosure of this today, Your Honor.
All right. So I don't know that there's any ruling by the court today that would have to be made relative to that, because it isn't even filed yet, so that there's nothing before the court. So ideally, what my instructions to the clerk's office by setting this event up was to get a trial date from you folks and then work backwards, like we would do with any wrongful death tort action, which this case is. I take exception to the defendant's notion that this is not just a tort action. It is. That's what it is. It's a civil case. I know there's a lot of people who are interested in this case, but at its heart, there are at this time eight parties involved in this case, correct?
Yes,
There's 5 for the plaintiff, and there's 3 for the defendants, 2 corporations and Ms. Reed. So that's the way the case is shaping up. You've got your tracking order, so you understand what the deadlines are now. I have the tracking order, I think basically shows this case as having discovery. Yeah, your discovery is supposed to close August of next year. Your Rule 56 motions to be done by October-ish of next year. Final pretrial conference February of 2027, with judgment by August 26th of 2027. So that's what the tracking order has in store as the case stands now, right?
That's
we
crazy.
could get you a trial date way sooner than that if you wanted to. I mean, literally, I could, the clerk and I were talking earlier before today's proceeding, and I may end up having to suspend, depending on what the circumstances. We were charging the jury on a homicide case earlier today. So we have a deliberating jury right now, so I don't know that I may have to suspend and then rejoin here in a little bit. But for now, so you understand it, we could get you a trial date as soon as practically this spring on this case. But to join 10 new defendants under wholly separate theories for people that haven't even been joined yet in this litigation puts that on its head. There's no way you wouldn't even have this procedural process outlined by the spring, most likely.
I understand that, and that's the dilemma that we're trying to bring to the court's attention, because there is going to be an affirmative pursuit.
Well, you're saying affirmative. You said earlier affirmative defense in this case, which those would not be affirmative defenses. Those are wholly separate third-party causes of action against people who are not part of this litigation, correct? So it's not an affirmative defense.
It's not an affirmative defense in the traditional sense, but it is part of the defense in the face of the wrongful death claims. The wrongful death claims stem from the same facts that the affirmative claims would be seeking to be pursued.
She's saying
against.
someone else did it.
So it is the same set of facts. If we were to file a separate action, Your Honor, where Karen Reed is the plaintiff and these parties that I've identified are the defendants, we would be pursuing down 2 separate pieces of behemoth litigation when we can consolidate them at the same time. That's what we're trying to suggest may be a more streamlined approach. And it's not intended to delay. It's actually intended to try and synthesize the process and conserve resources, attain judicial economy without prejudicing the plaintiff. Discovery is already ongoing. But to have 2 depositions, for example, of parties in 2 separate cases, where we could have one and the claims could proceed at the same time, just seems to make judicial sense That's why we're raising it. We'd like to brief it if the court gives us that permission.
Okay. All right. On that last discrete issue, anything else from the plaintiffs?
We have served them with discovery, asking them, they have a burden if they're going to do affirmative defenses to establish that there are third parties who are responsible here. That can be their affirmative defense, but they have a burden to prove that. And if they can't meet that burden, then it should never come into our case.
We
If
can
they're
prove it
seeking
just
to
as much as you can prove someone hit
overlap
her.
these two cases and throw it as far wide ranging as they've just announced, then there's no way that we would not be prejudiced by their strategy in the plaintiff's underlying case.
All right, those issues are reserved. I'm certainly not going to make any ruling on that. There's nothing formally before the court, no written motion, no Rule 9A or 9C certificate, none of that stuff. So it's not procedurally before the court, but certainly I appreciate hearing the argument nonetheless that this may be the future landscape of the case. What also brings us here, when I noticed the status conference for today, the defendants have filed motions to dismiss. If you're prepared, I'll go forward on that, let you deal with the substance of the motions to dismiss. I have read through your material, so I get the gist of what the defendants are raising. Counsel, would you like to proceed?
Thank you, Your Honor. As we've briefed, Your Honor, the counts that are at issue in the motion to dismiss are counts 13, excuse me, the counts 10 through 13. They are infliction of emotional distress claims. As we have presented in our papers, none of the plaintiffs observed the alleged incident that is described in the complaint. None of the plaintiffs came upon the decedent in close enough proximity to state a claim for emotional distress. There is the cases, Your Honor, limit when a claimant can claim emotional distress. The cases talk about temporal, spatial, and relational limitations.
Yep.
Taking the claim that Kaylee Furbush has alleged, that claim is for negligence / reckless / intentional infliction of emotional distress. And the basis of that claim is that there was a discussion on the telephone or discussion after Karen Reed had left 34 Fairview in Canton and had somehow started to fabricate a story about what had taken place. Kaylee Furbush was not at the scene, and the perception of someone dying is not an actionable claim under any case that we can find in Massachusetts state law. So she wasn't at the scene, didn't come upon the decedent, and therefore doesn't have the same types of proof, at least is played in the complaint, that would satisfy the limitations that the case law sets out, the temporal, the spatial, and the relational. With respect to the claims of emotional distress that have been brought by John O'Keefe's mother, father, and brother, again, they were not witnesses to the event. They came upon him many hours later. There are cases, and particularly the Cohen case that is cited in our brief, that speaks to the time that passes between an alleged event and when a family member or a bystander witnesses the consequences of that alleged event. And in that Cohen case, the court speaks to the fact that the mother of a young man that died in a plane crash didn't get to find out about it until many, many, many hours later, and the court denied the right to pursue an emotional distress claim. More importantly, Your Honor, there is a remedy here. If for the sake of argument, there is a remedy here through the wrongful death statute. And the wrongful death statute compensates for the types of harms that are alleged in the complaint. So what we're asking the court to do is to dismiss out the emotional distress claims because they are duplicative and allow the plaintiffs to pursue the wrongful death action singularly. We rest on our papers. Thank you, Judge.
All right, thank you. So let's turn to the other defendants, if they want to be heard. You've filed separate motions, essentially arguing the same relief, but if you have anything you want to add, you certainly can. Waterfall?
Yes, Your Honor, on behalf of Waterfall, just very briefly, I think the distinction here that counsel's making is that these claims, these infliction of emotional distress claims are intended when you're in the zone of danger or you're a recipient witness.
Yep.
And in this instance, it's many, many hours later that the parents are seeing the decedent in the hospital. I think it's after 7:50 a.m. And so based on what the Cohen case states and in terms of the principles that the courts have applied here, it just isn't, from a relational standpoint, close enough in proximity to be able to advance this type of claim. And in terms of the wrongful death statute, those loss of consortium damages, the damages of the loss of the son, if the plaintiff is making this claim going forward, are in fact addressed in that statute and obviously would be available as remedies to the plaintiff.
What about Semino versus Milford Keg Incorporated? I have a 1982 case that I found talking about the wrongful death, emotional distress injuries. Have you reviewed that case? I'll give this case site, 385 Mass 323. It's a 1982 case. So it would seem to suggest that that emotional distress is really not preempted by the wrongful death statute.
Huh.
Your Honor, I think the wrongful death statute alone would not necessarily cover all of the damages, but my argument would be more in line with the argument that in terms of where they are in relationship to the accident, since it wasn't witnessed, and since it wasn't immediately thereafter that they came upon the scene,
They're limited to wrongful
in a
death.
roadway, in a driveway, and observed the decedent, I would argue, Your Honor, based on that, that that's a problem for the plaintiff moving forward, and that would be the court's consideration. I appreciate, Your Honor, that there are some differences in the wrongful death statute and emotional distress claims.
Okay, thank you. Ferreter versus Daniel O'Connell Sons, a case that goes back to 1980, also kind of speaks to that issue too. Let's hear from C.F. McCarthy's on that. Anything else to add on the motions to dismiss? No. Okay. All right, great. All right, I'll take that issue under advisement. I do have some, I'll read through your briefs a little more closely.
Allow us to.
Yeah, of course. What I was going to say is that what will happen in just a few moments, I'm going to give the plaintiff an opportunity to respond to that. But I want everyone who's sitting here to understand that the comments I'm making now are not really doing other than just trying to tease out what the issues are. Motions to dismiss are not based upon the evidence, but rather on the allegations that are contained in the complaint. And those allegations, for purposes of a motion to dismiss, have to be accepted as true. And the question is whether or not the plaintiffs have stated a plausible claim under the case law, Iacchino and others that deal with this issue. So with that context, plaintiff, if you want to respond to both the motions to dismiss raised by, I should say, both the two corporate defendants and Ms. Reed.
I do, Your Honor. Thank you. The question that's really posed for this court is, like you just said, assuming all facts are true, indulging every inference in the plaintiff's favor, does the plaintiff's complaint plausibly suggest that plaintiffs are entitled to relief? The answer is yes. This is a motion to dismiss. The lowest standard, the Brum case, plaintiff's obstacle is a minimal hurdle, a relatively light burden, so long as the court looks at the allegations holistically. If relief to the plaintiff is plausible by the cumulative effect of all the factual allegations pled, we survive the motion to dismiss standard and we move forward to discovery like we should in all cases and in this one. There are three arguments that my brothers have put forward in this case. We oppose all three of them as follows. Number one, the defendants incorrectly state the law by suggesting that NIED claims are subsumed or preempted by the wrongful death statute. Number two, Your Honor, the defendants improperly seek to limit the scope of NIED claims by creating an arbitrary bright line test for such cases. Number three, Your Honor, the defendants failed to holistically consider the facts alleged and the known vulnerabilities of the plaintiffs when evaluating the defendant's extreme and outrageous conduct in violation of the infliction of emotional distress standard. I recognize that this court is not new to this case, and I recognize that most people already understand the facts, but I think it is important and significant that I at least highlight the ones that will be at issue here today. Throughout, we intend, like we did in the complaint, to refer to John O'Keefe as JJ. That is what he was affectionately referred to by his niece and nephew. JJ no longer has a voice. His life was wrongfully taken on January 29th, 2022. He lived a life of service. He was a Boston police officer, and his personal life, when JJ's older sister and brother-in-law tragically passed 2 months apart from each other, leaving 2 young children orphaned, JJ stepped up. He agreed to parent those children, to raise them as his own, and to support them. Fast forward to 2022, Your Honor. JJ is involved in a relationship with Miss Reed. It's been going on for a period of time at that time. January 29th, 2022, Karen drives drunk. She reverses her SUV. She knocks JJ down. She leaves him to die in the cold. And Reed knows that she strikes the plaintiff. Rather than seeking to help or calling 911, she returns to JJ's home. There, JJ's 14-year-old niece, Kaylee, a plaintiff in this case, is home alone, asleep. That's when Karen starts plotting. Now, it is significant for the facts for you to understand the context here. Karen Reed knows Kaylee well. She's been in her life for almost up to 2 years. She has served as a part-time maternal figure in her life. She knows that Kaylee is a vulnerable child, having lost 2 parents tragically. And 1 to 2 hours before JJ's body is ever found, before anybody knows his whereabouts, Karen Reed decides to wake up Kaylee in a panic. She tells Kaylee something happened to JJ. He's dead. He's been hit by a plow. Did I hit him? All to a 14-year-old child woken up from sleep who's already lost 2 parents. After provoking this chaos in the middle of the night, Miss Reed leaves Kaylee alone, vulnerable, shocked, and afraid. It's now 1 to 2 hours later. It's at or around 6 a.m. in the morning. JJ's injured body is now found. Right where Karen left him, buried in the snow, 911 is called. Now is when JJ's family learns of JJ's injury. JJ's injuries at this point enter into the O'Keefe's consciousness at around 6 a.m. They rush to the hospital. It's 7:50 a.m. That's when the hospital pronounces JJ dead. And within minutes of being pronounced dead, that's when the O'Keefe family sees their son in the injured state that he was in as a result of the wrongful conduct. From January 29th forward, Your Honor, Karen Reed plots, she fabricates a conspiracy, she launches a public campaign of disinformation, and she involves a blogger named Turtle Boy. She leaks not for public information through him. She pits her followers.
All right, real quick, I'm going to get right back to this road. I can see from the chat, Allie and I are going to have a lot of heavy lifting to do with you guys. This is not a criminal case. It is a civil case. It is completely different. It's a completely different burden that has to be met. They can allege anything they want, but we'll get to it. Remember, this is not a criminal case.
Right. And
Civil
right now,
are
all the
completely
judges
different things.
deciding is, have they said enough words? Just words. That's all that matters. Have they said enough words, the magic words, to state a cause of action, whether true or not true?
Right. And just so you guys know, when they're saying dismiss the complaint, they're really talking about There's
3
about
claims.
6 there. Yeah, I think there's a few more than that. I pulled up the thing. It looks like there's about 5 counts that they're looking to dismiss, all related to either negligent infliction of emotional distress or intentional infliction of emotional distress. So if the judge were to rule in the defense's favor and knock those counts out, the case doesn't go away. All the charges that are, or all the counts that are still existing, move forward. So we'll talk about it after, though.
Against the O'Keefe family, and all the while, Karen knows that the O'Keefe family is also vulnerable, grieving another tragedy in their family. The O'Keefes and Kaylee suffer severe emotional distress. It's more than anguish and more than grief, and it is not overlapping with the wrongful death statute. So the first argument that the defendants made, they claim that JJ's parents are precluded from bringing NIED claims because such damages are duplicative of the wrongful death statute. We reject that argument.
As did the judge.
JJ's parents are the next of kin, and their emotional distress claims are not preempted by the wrongful death statute. They took their first shot across the bow by making that their primary argument. Presumptively, they did so because it believed it's their best argument. But the problem with that argument, as Your Honor has already pointed out, it patently misstates Massachusetts law. You have pointed out the Cimino case, where, let me just point out, first, the wrongful death statute, it has 2 components for damages. It has 2 buckets of damages. It has the estate's damages. Those all are JJ's damages. His conscious pain and suffering, the medical bills, things that relate to his damages. And then we have the second bucket, the next of kin bucket. Those are lost value damages. The lost value of JJ being in his next of kin's life. And in that case, Your Honor, it is just the parents. Now, they suggest that those are overlapping with the NIED, but Your Honor was right to point out the Cimino case, where a drunk driver kills a 9-year-old boy. The father of that 9-year-old boy brings a case against the drunk and the bar for over-serving him. The father brings 2 separate causes of action, one for wrongful death, one for NIED, negligent infliction of emotional distress. The court held in that, and I quote, argument that plaintiff's claim for emotional distress is preempted by wrongful death action misconstrues the common law cause of action for emotional distress. Emotional distress, as the concept has evolved in the Commonwealth, is a severe psychological shock directly resulting from experiencing or witnessing the effects of the defendant's conduct. A claim for damages based on emotional distress, the court says, does not include an administrator's claim for loss of consortium, which will be present in every wrongful death action such as this. Since emotional distress is a wrong to plaintiff distinct from what was done to his son and the statutory beneficiaries of the decedent, it is not a duplicative remedy. It is not preempted by the wrongful death statute. And that's page 334 of the Cimino case, Your Honor. Cimino still remains good law. You were right to point that out. It directly contradicts everything that my brothers just argued here in this court. And I see no reason why this court should overturn the good standing law that exists under the Cimino. We ask that Your Honor deny the motion to dismiss for that first argument. The second argument that they make, Your Honor, is that the plaintiff's NIED claims are not sufficiently contemporaneous with the alleged accident because the family sees JJ 7 hours after the accident. That the law does not endorse such a narrow, arbitrary interpretation of the law. It is misplaced for the defendants to focus arbitrarily on the time of the accident, because let's look at the law itself. The liability for NIED depends on a number of factors: where, when, and how the injury enters into the consciousness of the plaintiffs. And it also requires the degree of relationship between those plaintiffs. But I repeat, where, when, and how the injury enters into their consciousness. It is misplaced for the defendants to suggest that it matters that plaintiffs were not at the scene of the accident. Because as you pointed out, the Farrader case stands in the exact opposite, where the plaintiff who rushes onto the scene and finds his loved ones injured has no greater entitlement to emotional distress for that shock than a plaintiff who rushes to the hospital, so long as the shock follows closely on the heels of. It is misplaced for the defendants also to suggest that there is a bright line test for the number of hours that passes between the time of an accident and when the injury enters into the consciousness of the plaintiffs. Your Honor has persuasive authority from the Zachary case that shows that an NIED case can survive even when the close family doesn't see the deceased body or the injured body until a day later after the wrongdoing. There is no bright line test. NIED is a fact-intensive analysis. And when we apply the law to the facts of this case, let's look at where, when, and how the injury enters into the consciousness of the people that we're bringing those cases for. It's 12:30 a.m. and nobody except Karen Reed knows about JJ's injuries. Defendant's wrongdoing continues into those early hours. She knows she struck him. She seeks no medical help. Instead, she chooses to cover it up and hides the injuries from anyone. It's not until 6 a.m. that JJ's injuries are even capable of getting into anyone's consciousness. The O'Keefe family immediately learns of JJ's injury, and they closely on the heels, they rush to the hospital, at which time they see the deceased body within minutes of him being declared dead.
What a fucking Weasley.
It is incredulous to think that a wrongdoer who hides the wrongdoing and the injury from anybody can be relieved of liability simply because the injury becomes knowable only after they disclose it. The defendant's cited cases are inapposite. They have no relationship to what is being asked of this court. They all involve a motion for summary judgment standard, which is a very different standard than the one that we are talking about here today, the motion to dismiss, the lowest hurdle to overcome. They try to equate it to a mother who learns of the rape of her daughter 7 months later, but that rape was known to other people within days. They try to relate it to the Migliore case, which has no relevance because it deals with somebody who has no close relationship. They didn't even know the decedent, and therefore it doesn't meet that standard. And then they rely on the Cohen case, which I heard both sides try to suggest has relevance. But in that case, Your Honor, the mother learns of her son's death 7 hours after the death. That's 7 hours after the injury occurred. And by the way, it was already knowable 7 hours earlier by other people when that plane crash was projected and the son of the woman who brought the claim knew about her own, his brother's death. The mother is 1,000 miles away, so spatial proximity is not there, and she only learns of it via phone. Does not experience the injury and never sees the body. Contrast that with everything that we talked about, Your Honor, where as soon as it was knowable, they learned about it, they rushed to the hospital, they saw the body, and they saw the body within minutes of him being declared dead. The purpose of the law is to distinguish between emotional distress from perceiving an injury versus the expected anguish that any person would feel from the death of a loved one. I want to talk briefly about Kaylee and her NIED claim. To suggest because she wasn't at the scene or because she was not at the hospital that day and they tried to spare her of that does not suggest she doesn't have a right. In fact, she experiences the trauma, the panic, the chaos of the injury contemporaneous with Karen Reed waking her up in the middle of the night and exclaiming that her parental figure, the third that she has now lost, was dead, hit by a plow or her SUV. Notably, this enters into her consciousness before anyone other than the wrongdoer knows of the injury. To the extent that defendant seeks relief
Goes against
because
his other
Kaylee did
argument.
not see with her own two eyes, I will refer you also to the Cohen case, which they cite for different reasons, but in it, the language talks about sensory perceptions. To suggest that you can't use other senses in order to perceive and experience the injury or the injurious event is wrong. Otherwise, no blind person would have a legal right under NIED. We have many senses. We use them all the time. And when it enters into our consciousness, it's hard to undo of it. It is very different from learning that your close family member has died. That is upsetting. It will be upsetting to anybody. But to have experienced the event or the injury and enters into your consciousness, that is the very reason and the foundation why NIED exists as a claim. So on that second, we also suggest that you should deny it because they experience the injuries closely on the heels of them being knowable and perceivable to anybody. Third, Your Honor, the defendants argue that the intentional/reckless infliction of emotional distress claim should fail because there's no extreme or outrageous conduct directed towards the plaintiff. But when viewed holistically, the facts demonstrate that Ms. Reed should have known her extreme and outrageous conduct would be detrimental to these vulnerable plaintiffs. And I use the word vulnerable plaintiffs because it's relevant to our case law, Your Honor. It's misplaced to suggest that the conduct needs to be directed immediately towards those plaintiffs. As long as she should have known that the emotional distress was the likely result of her conduct, that's sufficient under the reckless infliction of emotional distress standard. So how do we evaluate what is extreme and outrageous? It's fact intensive, but the law does recognize that some critically important factors that need to be considered when evaluating what is extreme and outrageous. Plaintiff's susceptibility, defendant's knowledge of that susceptibility, and the relationship between defendant and plaintiff. The case law all suggests that that gives rise to extreme and outrageous conduct. In evaluating whether defendant's conduct was extreme and outrageous, the courts should consider whether individuals at whom conduct is directed is known to be particularly susceptible to infliction of emotional distress. Boyle versus Wenck, 1979 case we cited to, Your Honor. Our case law has recognized susceptibilities to evaluate extreme and outrageous conduct to be a recent hospitalization in the Boyle case, a cancer patient in the Harrison case, elderly or frail people in the Bailey case, or children, minors, based on their age in the Sarkonis case, all that we've cited to, Your Honor, and I'm happy to give you cites. The law in Roman versus Trustees of Tufts College says, as it relates to this, the court should put as harsh a face on the defendant's actions as the basic facts would reasonably allow. The relationship of a plaintiff to the defendant and her knowledge of the plaintiff's sensitivities is an important consideration in determining whether the challenge conduct satisfies the extreme and outrageous conduct. That's the Russell case. Let's talk about Kaylee as it relates to the infliction of emotional distress. Should defendant Karen Reed have known that emotional distress was the likely result of her conduct? Was defendant's conduct extreme and outrageous? Those are the questions that ultimately we pose to a jury. Kaylee was young, 14 years old. The defendant had a relationship with her, knew she was emotionally fragile, knew she was orphaned at the age of 6, knew that she lost both parents tragically. The defendant assumed this pseudo-parental role with Kaylee for nearly up to 2 years. The defendant, Ms. Reed, knows that she knocked JJ down. It's the middle of the night. She wakes up Kaylee abruptly. She talks about JJ being dead, being struck by a plow, being struck by a vehicle. Mind you, this is all hours.
So it wasn't someone's
Before
consciousness.
anybody has even discovered his
Right or
body,
wrong.
and she is now actively talking about him being dead. Then, after creating this chaotic, upsetting situation in this young, fragile girl's psyche, she leaves her. She leaves her home alone, shocked and frightened. Compound that by defendant's choice to speak her false narrative publicly, to use social media, to leak public information through Turtle Boy, to control that narrative. Why is Turtle Boy out there saying the O'Keefe's family period of grief has expired and they are now fair game? Who leaked the autopsy photos that got published by Turtle Boy for this vulnerable family to have to be exposed to that they weren't seeing before? To the extent that the defendant argues that
Why are
this
they
is
joining
not
Turtle Boy then?
extreme and outrageous, remember the law. It is the jury's role to decide whether the defendant's conduct was rude and clumsy or extreme and outrageous. That comes right from the case law. As it relates to the family, Your Honor, should the defendant, Karen Reed, have known that emotional distress was the likely result of her conduct? Was defendant's conduct extreme and outrageous? Again, those are the questions posed for a jury ultimately. But the law says conduct which the actor should have known would result in distress is actionable. And the plausibility standard, the motion to dismiss standard, which is where we're at right now, Your Honor, simply calls for enough facts to raise a reasonable expectation that discovery will reveal evidence of the illegal conduct. Margaret and John have now buried 2 children. Paul has buried all his siblings. Defendant always knew this. She has always known their vulnerability, and yet she creates a calculated and malicious campaign of disinformation designed to hide the truth in this case. She pits the O'Keefe family versus the Reed family, and a reporter who she asserts editorial control publicly proclaims to Reed supporters, the O'Keefe family's period of grief has expired and they are now fair game. Discovery will track how much leaked information defendant should have known would result in distress to the O'Keefe family. To the extent that the defendant suggests that this case sits nicely within any other case decided on this issue, remember the facts and circumstances here are exceptional. We wouldn't have these TV cameras or a full courthouse if they weren't exceptional. That is why we are here, Your Honor. It doesn't fit within a nice box like every one of those cases I cite. The Polay case where we talked about false police reports and harassment petitions were not considered towards emotional distress because they were petitioning activity. I want to talk about that briefly because what Ms. Reed has done is not petitioning activity. It is not asserting a defense within a courthouse or having her legal counsel assert that defense or testifying at a court hearing. Instead, what Karen Reed is doing is not petitioning at all. She is waiving her Fifth Amendment privilege. She's speaking anywhere and everywhere that would give her a friendly audience with editorial control. She's gone on Dateline, Nightline, 2020, Fox 25, Boston Magazine, Vanity Fair, WEEI, Turtle Boy, HBO Max, ID Discovery, etc. There are more. This is an exceptional case that requires exceptional discovery, that requires us to decide this matter by a jury, not by a motion to dismiss phase, Your Honor. It is not like the Quinn case that they cite where there's an open adulterer involved, and so they think that's not extreme and outrageous. And it's not extreme and outrageous like it has nothing to do with the employment case where they fired somebody who had a criminal case pending, then they brought them back on, and he didn't like the way that they treated him after he was found not guilty, which is different, by the way, than innocent. The court should deny the third of those arguments. They should know that plaintiff's susceptibility and vulnerability are at issue in this case and are the very reason and foundation why it is extreme and outrageous conduct, and that defendants' improper actions would cause severe emotional distress. Defendants' actions were not rude and clumsy. They were extreme and outrageous. We ask Your Honor to allow this case to go forward with discovery, allow us to explore each and every one of those issues, because these are real damages for real people who have suffered long enough. Thank you.
All right, thank you. Any response from the defense?
Your Honor, briefly. Firstly, those allegations contained in the complaint are allegations which we will refute. Counsel cites to the Camino case, relies heavily on it. What counsel didn't tell the court is that in the Camino case, the father of the child who died in the car accident was himself hit. Part of the car accident, gets up, runs to see his son. It's contemporaneous. It's at the time of the event. And the court didn't have the same spatial, relational, and temporal concerns that the cases speak to with respect to emotional distress claims. So I point that out for the Your Honor. He also mentioned much about conspiracy theories, much about going out in the public and creating a narrative, which is precisely the reason why we're going to brief the issue about why those other parties need to be in this case. As I'd said, it is more than just a wrongful death action, Your Honor. I respect the opportunity to brief that, and we rely on our papers and defer to the court on the motion to dismiss.
All right, thank you. Any other defendants wish to be heard on the issue? Anything else? All right, thank you. Certainly, there's a lot to the complaint. And again, for the record, so that people understand this is a pre-discovery form of relief that the defendants have sought by way of dismissing certain of the counts that are in this complaint. And the court has to consider the allegations as being truthful and every reasonable inference to be drawn in support of that. So I will look forward to reviewing that. I'll issue a decision as soon as I can. As expected, the lawyers in this case have advocated the positions of their clients very clearly, and I expect that with the procedural things that it might be asked for at some point, that this case will have a very long and tail to it as it goes through the litigation process. We expect that in the court system, we give people their ability to try cases and get a jury to listen to the arguments and to ultimately make a decision. My experience in doing this for a very long time in different contexts is that doesn't oftentimes bring the relief that people think it does. And so as a result, there's appellate processes. And so what I envisioned for the parties, unfortunately in this case, is a very long and sort of complex process that litigation provides. And you know, this is a civil case, it's not a criminal case. There are 8 parties as I identified, and those are the people that the court will be concerned with getting a fair trial at some point down the road. As I said, I could do this case, I could do this trial this spring if you'd like to. My sense is that there's nobody that's going to be ready to go to trial by the springtime. If you want me to sign a trial date,
not a
we
chance.
can do so. I mean, literally, I've talked to the clerk, we could do it in March or April if you'd like to. But with the motions that are going to be pending, I suspect that that's not going to be the case, that you'll have to look at this from a more pragmatic point of view and decide when you're going to try to get this thing to a jury. You have a lot of work to do between then and now. I'd like to still get a trial date for you. Now, I don't know what that's going to mean in terms of bringing in other parties. I didn't expect, because the court has had no notice, that there'd be this interest in trying to move this complaint in the direction of other parties who aren't even named in this lawsuit, 10 additional parties. And there's relatively novel theories as I'm hearing it, but nonetheless, we'll let the parties file the motions that they need to, and we'll address them as each comes. But my point in raising this all is that the parties also have another way to do this case. They can do it by way of potential resolution. And I mean this sincerely when I say that being a judge for many years, you learn things. What you learn is that oftentimes litigation is an inartful way to try to resolve parties' disputes. There's alternative dispute resolution, there's mediation, there's all kinds of other avenues that we advance to try to get people what they want, which is resolution of a case. The most important thing, it would seem to me, to any party to this case, is to resolve the uncertainty, right? Uncertainty is what you don't get when you go through the litigation process. You go through and you hope for the best. Lawyers work really hard for their clients, and we expect them to do that. Ultimately, the court system can make sure that the trial is done, and it's done in a way that's fairest that we can make it. And ultimately, a decision is made. Civil cases, though, are very unlike criminal cases, and that's usually not the end. Ask any of the lawyers here. Clients can ask your lawyers about post-disposition or post-verdict process. It can be really long and arduous. I've had the pleasure of having trials that are 16, 18, 20 years old, and they're still going. The clients don't have to do that. The clients can try to put some efforts, at least as much effort in the litigation process as trying to resolve it. Why do I say that? Because resolving cases resolves uncertainty, which is perhaps the most important thing any client can get in a case. I say that because you'll have that opportunity through all the process. You've heard me outline it. Your discovery isn't even closing until the discovery is going to close next December, but it's really 2027 that you're looking for a trial in this case realistically. Again, we could do it in 2026 in the spring if you want to. And I'm going to ask the parties to work collaboratively to try to come up with a trial date that is workable. I understand that's a wrench that's been thrown into the works because of this other process. We'll probably have to deal with that in the short term. I'll pledge to try to get you what you can as quickly as I can. I tend to get decisions out pretty quickly. I tend to try to move things to get parties what they want, which is ultimately their day in court. I'm just telling you at the outset that I think that it's worthy of exploring possible resolutions on your own. You can do it through this court. We have a mediation process that you can avail yourselves of, judicial settlement conferences. You can go through private neutrals, because there are now 8 parties involved in this case, 2 of which are corporate defendants, 1 of which is Ms. Reed. And so that's going to give you a lot of opportunity for dialogue. My sense is I'm probably wasting my time by doing it at this stage of the process, but I think it's important that your clients know that there is an alternative way out of this. Money damages are all the plaintiff can ask for. Nobody can restore, we say this when people lose loved ones or that they have some meaningful part of their body or mind that's been lost in a litigation. We can't restore that. We award money damages. And so ultimately that's what the imperfect litigation system will have. Knowing that, there's a huge opportunity to try to resolve a case like this. And I would urge the parties to have very frank discussions with their lawyers about that and ask yourselves, is it worth going forward with all the uncertainty? And I'm not going to explore with your clients what everybody has to lose. Everyone knows that. If I were representing a plaintiff in this case, I would tell them all about things like the time it takes to get to litigation, what we have the burden of proof. Yes, it's easier with a burden of proof that's by a more likely than not standard versus a proof beyond a reasonable doubt, but still it's a burden of proof nonetheless. But there's a time value of money. People don't, getting this behind them is an important issue. From the defendant's point of view, again, time is money. There's a lot of time, effort, and anxiety that is put together with a litigation like this. We have 2 ongoing, as far as I understand, the 2 businesses in Canton are ongoing, and they have their business decisions they have to make. Ultimately, they're defendants in this case. They have to understand the risk of going forward in a trial versus resolution. Of course, Ms. Reed herself, a lifetime of potentially facing the uncertainty of a judgment and what that will mean in terms of ability to put this matter behind and going forward. It's going to be very complex. So you can resolve that by looking at putting some effort into this case to resolve it. If you can, great. If not, we stand here committed to giving you the next opportunity to get it before a jury, which I'm suggesting to you could do as soon as this spring.
We heard you, Your Honor. Come on now.
Anything else we need to address this afternoon?
Not from the defendant, Your Honor.
Okay, great. I'll issue a decision on the motion to dismiss. Tracking order stays in place as it is now, but here's my concern, folks. With this motion that the defense team is talking about putting together, I think that needs to be looked at sooner rather than later. It's a big deal, right?
Yes, Your Honor.
Okay. Why don't we get a status date? When do you want to, and we can do by Zoom, folks, if it's just as easy. My order was to have everybody here so that you all get a chance to meet. I want people to be understanding that this is a civil matter, and I want you to be, at least to some extent, trying to be civil about how to resolve your issues. I would have liked to see, for instance, this motion that was brought about in open court should have really been discussed ahead of time so you have a better position on it, but I don't want to waste your time. You want to do the next hearing by Zoom? You want to do it in person? You tell me. Plaintiff?
We're agnostic, Your Honor. I'll do what.
We're agnostic? Is that what you said?
Yeah, as it relates to that. We'll come in person or we'll do it via Zoom.
Defense?
Your Honor, we prefer to be in person.
Okay.
Why?
Okay.
For a song and
All right,
dance?
we'll do it in person. Fine,
Yep.
we'll do it down here in Plymouth.
That's right.
I will be moving into the Brockton Court next month, but this is especially assigned, at least for now, so I'll come back down here. That's not a problem. Mr. Clerk, do you want to suggest a date for us?
Sure. How many days out you want to go? 60 days, 90 days,
Yeah, probably 60 days.
50 days? November 21st, Friday in the end of November.
Yeah.
Yeah, like Ellen wants to
November 21st.
be flying right before
Okay, I'll have a
Thanksgiving.
decision out before then, certainly, as quickly as I can. 11/21, and that would be for a status regarding tracking order and discovery. And any motions,
Sure.
Rule 15 motions to amend or bring in third parties. Okay, all right, thank you, folks. We'll see you then.
Thank you, Your Honor.
Keep an eye on it backstage there so we can see if there's some sort of press conference or unless you guys want to watch
Nothing with the
chit
jury?
chat.
Look at this distinguished gentleman. Look at the way he is sitting. Yes, very distinguished. I see.
You can really hear Terrence hot mic a little bit.
All right.
Yeah, all right. Yeah. Thank you.
Yeah, civil court's a whole different beast. It's a whole different beast. So there's a couple things.
Well, first, I just want to comment about the judge, really wanting this to settle. Now, I kind of, understand his point because this is going to drag on forever. But it almost shows that he's sort of out of touch with this case because the O'Keefes don't want money. You know what I mean? Like that is of no consequence to them. They want Karen to admit or be found guilty.
Liable.
Right, liable, whatever.
Liable. Not guilty. Well,
Guilty.
don't get
In their minds, they
Hey,
want her.
Don't confuse the chat. It's not
Okay,
guilty.
I
This
won't
is an
confuse
criminal case.
They want her to be
Civilly
found
liable is what it is.
liable.
It's a
We're
very
trying not.
different thing. But
Yes.
you're right. You're right. At the end of the day, this is not about money for the O'Keefe family. And
if Karen could pay money
God, you
without
keep
admitting
jumping
any.
in. You keep jumping in. I'm about to like say something.
All
You know,
right.
I always have pregnant
Go
pauses.
ahead.
I'll
Go
talk faster so that you don't interrupt me. Like the whole thing with civil cases, which I kept telling you guys about during the criminal trial, is that there is a massive amount of discovery that takes place. And it is so different than criminal trials. The depositions in these cases, and I'm talking about if they bring in the other 10 defendants, this thing will not go to trial for 7-8 years. It will take that long in order just to have all the discovery take place, because it's not just all the depositions. It starts with they're going to make production requests, which is where you're asking for X, Y, and Z. That's all paperwork, or if it's text messages. And we all know all the shit that has been alleged with this case that has been going on in the phones, people's phones. All of that is going to be fair game in a civil trial. That's Karen's phones. That's Turtle Boy's phones. That's the McCabe's phone. That's everybody's phones. Like the issues that they had in the criminal trial with getting all from the McCabe's, the Alberts, all those folks are not going to be the same issue that they have here in the civil trial, because they're trying to prove different things. Like there is no being found guilty in a civil trial. The civil trials are all about money. That's it. And liability. And like Allie was saying, and I agree 1,000%, the O'Keefes don't give a shit about the money. Think about it in terms of the OJ case. He's found not guilty. And then both families turned around and sued OJ civilly. And in that case, he was found liable. And if you watch Fred Goldman come out like after that case was heard, like he didn't care about the money. He cared about exactly what Allison was saying. He's like, we knew this guy killed my son. And I feel today it's one of the most fulfilling days of my life, because a jury went back and they found what everybody else should have found in that criminal trial, that this guy did it, and they held him responsible, even though it's civilly. So, I mean, that's what the O'Keefe family is looking for here. And it's going to be messy. Like it is going to be messy. And if you're bored by civil trials, well, buckle up, because the motion work in civil trials is never ending. It's never ending. They will be bickering about, they will have so many motions filed about discovery that one of these potentially 19 parties doesn't want to turn over, and they'll all be bickering with one another. And they're all going to be trying to say, hey, we don't have to turn this discovery over. And the amount of depositions are going to take. And when you're talking about the Waterfall and McCarthy's, like they're probably a dram shop case. Dram shop is where they've overserved somebody and that person has gone out and done something. Like in this case, they're alleging that Karen hit John. So, and I'm talking about the plaintiffs. So all of that shit's going to come out. There's a bunch of different claims here. It's going to be a lot of work to get this thing to trial. So, I mean, any civil trial babe is going to say that, or any civil judge is going to say, because I mean, most cases civilly settle. That's facts. But this is an exceptional case. This is not the norm. You know what I mean?
Right, for sure.
So that's it. So come on, dude. I was
just gonna say,
you interrupted me 2 times. So like now, oh, come on, man.
I was just gonna say that I don't remember what I was saying, Bay.
I know that's how it is when you interrupt me, then I forget. because I'm like slow playing it, and then you're like, boom. I mean, what's your prediction on whether or not this thing's going to go to trial at all?
I think it's going to go to trial.
And what is your prediction?
Well, unless they can win on a motion for summary judgment, but
right. Well, so explain that.
Hold on one sec.
So a motion for summary judgment is essentially going to be filed post discovery in this case. Potentially, it could be.
It's going to be filed. It's going to be filed.
It's definitely going to be filed. It's definitely.
So I was just going to say that that although, and I see a lot of people saying like they want money as a way to punish Karen. So I agree with that concept, but I think there's, even if paying some form of money could end this for Karen, let's just assume she could offer to do that without admitting any guilt. I don't think that, or liability. I don't think, or any wrongdoing. Like it's a settlement with no admission of any wrongdoing, still maintaining that she did nothing wrong and that she's paying, what's the word that I can't think of? Whatever. Like an annoyance fee, just to get it to go away. Like, that's not going to that's not going to resolve the O'Keefes. They're not going to be like, oh, okay, that's fine. I don't think even if she offered, not that she would, but even if she offered $3 million and said, but I'm not going to acknowledge that I've done anything wrong. I didn't do anything wrong. I don't know that would make the O'Keefes happy. And I can't in a million years imagine if the O'Keefes asked for $1 with an admission of wrongdoing, that there's no chance in hell that Karen would do that, especially because I don't think she did anything wrong. So,
yeah, I think you're looking for nuisance was the word that you were looking for.
Looking for. Thanks.
So, yeah, but here's the other part of it. I think that one of the defense attorneys for Karen is probably from her automobile insurance. So, I mean, she's got insurance coverage here. That's one of the things that people kind of may not know about civil law, especially in accident cases, where you'll see the named parties are the two people that were involved by the accident, but typically it's your insurance company if you're, again, involved in a car accident.
Well, do you know who that guy was?
I don't know. I was trying to find him. I was trying to find out who he was.
Maybe he was hired by the insurance company, and that's why he's lead.
Yeah, I was also trying to figure out, look more into who was representing the O'Keefe estate and the O'Keefe family, because the way that civil, and this is the other thing about civil trials is vastly different than criminal trials, in that typically plaintiffs' counsel takes cases on a contingency basis, meaning that they front all the cost. And in this case, the fronting of the costs is going to be massive.
Astronomical.
Massive. Like everything that we saw in the criminal case, you're going to see again, and probably better done by plaintiffs' counsel than was done by the Commonwealth, in terms of them hiring on somebody that's not Aperture, that is going to come in and try to prove their case civilly, that there in fact was a collision with John O'Keefe's body in the Lexus. So, I mean, all of that shit's going to come in. It's still the same set of facts. They have a different burden here, and there's going to be more money involved from the civil side of it, because as much as they paid Aperture, if this, and I was trying to figure out who the civil law firm is, like Chicago, like the biggest civil law firms in Chicago are fucking wealthier than God.
So
like they have
Miller Law LLP. So I'll
dig around, see what you can find. So, there's just going to be a huge amount of money spent, but that's that factor of, you've got a plaintiff who has hired a lawyer who may or may not have taken it on a contingency basis. And if that plaintiff's lawyer doesn't believe they can recover, because as much as the O'Keefes want to get a definitive answer that they in their minds want justice in terms of a civil jury coming back and say, yeah, we think that Karen hit him. You know, that the preponderance of the evidence is that Karen hit him. And then that's what the problem for the lawyers is they only care about that in the sense that they're liable and they have to recover money. Like these guys are not doing this for free.
So let me ask you this. If they're doing this on contingency, right?
Yeah.
They can't think that there's a good chance they're going to win. They just, if their heads haven't been up their asses, they can see the public is split. Two juries, one jury was split. One jury found that car did not hit that body. They have to know there is a very good chance they're going to lose. If you were that plaintiff's counsel, would you think the notoriety that comes with the case and all of the coverage and is worth you losing at the end?
Me personally?
Yeah.
No, I'd run from this case a million
Right.
miles an hour.
Yeah.
This is a case that I wouldn't touch civilly because, and the other part of it that you have to think about in terms of civil cases is who's the deep pocket. Because even if it is Karen's insurance carrier, and again, I'm thinking like, even if we're assuming what Ali was saying about the O'Keefe family is true, that they don't necessarily give a shit about the money side of it, the lawyers do.
Right.
The civil plaintiffs' lawyers care about the money. That's why they do this shit.
Right.
Like that. It's so those two things are kind of
like money.
conflicting.
Yeah, I like money though.
If we will find out through discovery what the policy limits are on her vehicle, I mean,
it's probably going to be
that'd be a policy, right?
I would, it's probably a typical policy. Like Karen probably maybe $1 million.
That's what I'm saying. At the most, it's $1 million.
At the most.
If the insurance company, now here's the thing. The negligent, I think that's the wait a second.
I could already tell that dude Brian was not the lawyer in the Cardi B case. Like that guy's done. You can tell, even though you guys found him boring as shit. I mean, he does a lot of civil plaintiffs work. You can tell.
Oh yeah, he was way better than.
Oh
Cardi
yeah,
B's
that was like
he opened his mouth.
Yeah, exactly.
But
yeah, no, I mean, there's no way I touch that. But this case has those. It's got that thing where you attach yourself to the case. There's potential for income from other sources.
Right, but even when you lose, because I can't imagine them winning at the end of the day.
I mean, you say that, but it's a much lower burden.
They still have to prove a car touched a body.
I get that, babe. It's a much lower burden. It's a much lower burden. And, I mean, you're talking, if this thing takes 5-6 years.
Yeah, I mean, I guess it's
the
possible
trial
that a jury can decide when they have no other reasonable alternative that.
Well, that's where it gets super interesting. So it's not a foregone conclusion that the judge is going to allow the countersuit. And the countersuit is against the 10 parties that counsel brought up. I mean, I think he should, in the sense that it all stems from the same occurrence and set of facts.
Right.
So, I don't see, I can see why he wouldn't want to. I mean, having 19 parties, it's like a RICO case on the criminal side.
It makes it highly prejudices the plaintiff to have to defend, in a sense that they're having to be involved in all those counterclaims. You're gonna have to do all those depositions, and maybe they don't have to do the legwork on the motions, but lawyers are gonna have to show up at those depositions.
Yeah.
But at the same time, I think those depositions would take place anyway. That's the thing the plaintiff's counsel is not thinking, is that they're going to do all those depositions anyway. They're going to bring on all that same information anyway, because they're going to be presenting the defense that somebody else did this, no matter what. So, I could see the failure to, like negligence and not securing the vehicle. That
Well, the other interesting part is that they're going after them personally. And I'm talking about like the proctors because
Oh yeah, it's intentional. You got to.
yeah, but it's well, I mean, it's alleged to be intentional
Well,
for the purposes
mm,
of the lawsuit.
mm.
So, I mean, but because it's very difficult to sue the government. I mean, governmental immunity is very difficult to overcome. So the Canton PD, the MSP potential suits, pulling them in is going to be a very difficult thing to overcome. It just is. I mean, the government has a lot of power, and that includes civilly in terms of being able to sue them. So, no, this is not the trial. It is not the trial, Jamie BB. That is a status date. This thing is going to take forever.
Yeah, they're
Forever.
not. It might be. It might be. I mean, it's definitely not
I'm
going to be until
guessing 5 to
2027. It
6
could be even
years.
2028.
It could be 2030. I mean,
That's
that's no joke. I mean, we've done civil work. You know how long that shit can take. It could, with this many people potentially involved, with that much discovery, with that much litigation,
so.
and you never know, like what's going to happen after like after a deposition takes place, and if it goes your way, depending on whatever side you're on, that's typically when you're going and talking to that particular either plaintiff or defendant and saying, "All right, you want to settle this thing?" Because
If
your guy
I'm
just
the
fucked
if I'm
himself.
the bars, I would try to settle for some sort of
Yeah, nuisance. Yeah,
nuisance fee.
I agree.
And they might, and if they might just take that with them, who knows?
And
Because
there's
it's
probably a cap too. Like there's a cap in Illinois on dram shop. Like you can't, like you're not ringing the bell on dram shop. That's not where you're getting the money. That's like the bars are not the deep pockets here. I can guarantee it. Especially in a drinking ass state like Massachusetts. I imagine the dram shop is pretty friendly for establishments. You know what I mean?
I was trying to see if there is a maximum recovery.
In dram shop.
Yeah, I don't see anything popping up real quick. I'd have to look at it, but
Yeah, here it's like in Illinois, it's a ridiculously low amount. Like
but how can it be when they don't know what the damages are?
What do you
The
mean?
wrong, like
There's
a wrongful death versus a broken leg.
on dram shop.
Yeah.
I mean, they just have a cap in terms of as much as you can recover. I mean, there's a cap in Illinois. It's like it's ridiculous, and it's really low. It's like I don't know what lobby got that thing passed, but some lobby did.
So, Melanie Parker says John O'Keefe was killed in the garage, no case. So, and that just brings us back to like, and Bob started to talk about it, the difference between a motion to dismiss and a motion for summary judgment. And the judge spoke about it, and we kind of talked about it a little earlier. They're literally just going off of the words on the paper. If they are able to prove the words on the paper and the judge takes everything they say is true, is it enough to state a cause of action? So no counter argument like, well, he was killed in the garage and there's proof of that. That none of that comes into play. There's no balancing of what the other side says. There's nothing like that for the purposes of this. And like Bob said, that's why they haven't even tried to dismiss the wrongful death case, because they've said the words and it has to go to a motion for summary judgment. But Kiefer TX, maybe Texas, says, how can you sue for wrongful death when the person was found innocent? This country sucks. The burden of proof is very different. The jury wouldn't even know. They wouldn't hear about her being found not guilty in a criminal court of law. But, one's beyond a reasonable doubt. And so that's why.
Ironically, though, if she had been found guilty, I mean, I wouldn't think that.
Well, then there would be no right.
I
Then,
mean,
then liability would be done, and we'd just be talking about damages.
Right. Exactly. So, because there's always two parts of a civil case. There's the first hurdle is proving liability, and then if you're able to do that, then you get into the damages. What are the damages? And it's almost like two separate trials. but you first have to get over the liability hump in order to move forward in the case. And like Ali said, they're definitely going to be filing many motions for summary judgment in this case. And
well,
kind of the easy
one
way to
motion as
explain
several
it
counts.
is that there's just no factual dispute. But like I don't see any kind of summary judgment in this case in particular being successful because there is factual disputes. I mean, like this thing is going to have to.
What
go
if
to
there
the
is
jury.
no evidence, even to reach the bar of establishing by clear and convincing evidence that the vehicle hit the body? I
Well,
mean, I guess as long as they have one expert to say the vehicle hit the body, then it comes down
right.
to a
I mean,
question of fact.
that's
So, and that's what Bob and I are talking about. If there is a question of fact, meaning one expert says the vehicle hit the body and another expert says the vehicle didn't hit the body, it becomes a jury question to decide which of the two experts is right. If there's not a question of fact, as there will be, for example, with the intentional infliction of emotional distress, I think there's certain things Karen admitted as far as I think waking up the daughter and saying certain things. So that's gonna
the niece.
the niece. Well,
Yeah.
I mean, I guess was she not legally adopted by him? I
Yeah,
guess.
but I mean, it's still his niece.
Well, not if he's legally adopted. It's his
Wait,
daughter.
yeah, he's the guardian and the adopted. I mean, huh?
If he has adopted her, she is
That
his
doesn't.
daughter.
What is that true?
When you adopt someone, yeah.
Wait, so is that true?
Yes.
I don't think so.
Well,
So
he
you're
could be the
saying if
guardian without
your
having
niece
gone through the
becomes
adoption.
your daughter?
What?
What? So you're saying if we were to adopt Jerry, she'd become our daughter? She's still
Yes.
our niece. We're
No.
just her guardians.
But that's a different process. Is he the guardian or did he adopt her?
I think he did adopt. I don't know
Well,
if
then
he
it's
did.
his daughter.
Actually, I don't know. When I think about, I don't think he did adopt him. I think he was in the process.
I would think that
where
if he had, they would have been next to kin, and she would have been able to maintain her own wrongful death suit. And they said in there that the parents were the next to kin. So I don't believe a legal adoption occurred just based on that. But
I am stuck on this.
you're being ridiculous, though.
I don't know, dude. It's like that doesn't what?
Are you kidding? What does adoption do? What is the point of adoption, babe?
I mean,
Right.
it doesn't change the biological relationship with the
Well,
person
no, if you
adopting.
want to maintain just
I think what adoption does is it legally makes you responsible for that person. I don't think it changed. I don't know. I'm gonna have to
yes,
look that
it
up.
absolutely does.
I know that you're
No ifs,
saying
ands, or buts, babe. That's what
I'm
adoption
gonna go why? Because you've done so much adoption law.
I mean, it's just it
disagree.
is. It is. I just don't get what you're saying.
I don't think you become.
Yes, when you adopt someone, you become their parent. They become your child legally.
Well, they become your charge.
They become your fucking child legally. They become your daughter or your son. I'm like sitting over here thinking there's got to be people who have been adopted or adopted people. They're like, what are you saying, Mr. Robert Mata, right now?
No, I don't know. I think it's still your niece.
Biologically, yeah. If you want to say biological, yes. Okay, here. Half Fish says, I'm adopted. Wait, I clicked on the wrong thing.
Ever heard the phrase "my adopted daughter"? Of course, but that's like when you're adopting somebody who's not necessarily related to you.
Right, so that's what you're thinking, that there might be some kind of difference when you adopt someone related to you. And
Obviously.
I'm saying no. I don't think there is. There would be no.
Yeah, you guys are you're misconstruing what I'm saying. Obviously, if you're adopted, you're in a parental role. If you're adopting, say your siblings' kids because they died, I don't know that you become dad.
Yeah, you do.
Well, I wouldn't, because I'd be respecting my brother and say, well, I'm still your uncle, but we're your parents in terms of giving you a place to live and making sure that you're taken care of. But you know what I mean? I don't know. It's a weird thing to me. But clearly I understand the concept that if you're adopting somebody that is of no relation, obviously you become the parents.
All right, PB and Shelley answered the question. The Daybells, JJ was their son legally. And there's no question of, right?
What?
That JJ was the Daybell's son.
But he, again,
Charlie, I mean, not Charlie, whatever. Was it Charles?
Charles Vallow, yeah.
Vallow was
The uncle.
the uncle and the father, right? Okay, so let's move on from that discussion.
I don't know if he was like,
he was.
I don't remember them saying Charles was JJ's dad. I don't know. It's a weird thing for me.
I understand your point that if you adopted your sibling's child, you would still want them to call you uncle.
Right.
Even
They
though
would
legally
still call me uncle.
Even though legally
Not that I would want them to. They would
That's
call
weird.
me uncle. It's not weird, Mandy. It's weird that you would, if you adopted your sister's kids, God forbid, you wouldn't want them to still call you Aunt Mandy. You'd want them to call you mom. Come on, dude. No, that just feels wrong. It's a thing.
All right. So let's go to Chip. 9 lawyers. Tell me your client isn't liable without telling me your client isn't liable. I mean, tell me about wasting money without telling me about wasting money. I just don't. It's just, unless all of those lawyers are working for free, it's obscene. It's obscene.
I mean, you think all those lawyers are working for her for free?
I can't imagine that anybody, that anyone but Alan would. And now you just said that oh, it was Alan who was coming on today. I thought.
Yeah, Alan. I didn't see Liza in there, but I mean, I've heard like she comes along with Alan. When you get Alan, you get Liza. So I don't know.
Aunt member for 3 months. Thank you for your continued support. Copy and paste states opening, even though she's proven not guilty. Brilliance. I mean, it's what I'm wondering is, under the law, this concept about the coverage. I don't know if that's extreme and outrageous conduct under the law, as a matter of law. But I guess we'll see what the judge has to say. And I think it's important for the plaintiffs to keep that additional count because it's not connected to the driving. So they could settle the wrongful death action for whatever the insurance company is offering, and still have that claim going against Karen Reed.
Right. It's not dependent on that. I mean, it is and it isn't, because they're alleging that she knew. I mean, he said it flat out. She knew that she hit JJ. And then she came in and told Kaylee this and that.
So that went against their whole thing. They were like, it wasn't in anyone's consciousness. Nobody knew he was dead. And then they turned around and said, right or wrong, right, that Karen Reed told the niece daughter that he was dead. So, no, now we're talking
I think
about.
It's that thing where Karen was just kind of puking out all the shit that, I think in Karen's mind, and probably when she gets deposed, and she will get deposed, when they get into because they'll be able to get into all that shit in the depositions. Like,
that'll be an interesting deposition.
It'll be a really interesting.
I'll tell you, it's
deposition.
been one of the things that has really stuck in my craw from the very beginning about why is she assuming it, as soon as he can't be found, that he was hit by a plow? And then Bob told me it happens all the time. Not all the time, but you just told me it's not a rare occurrence out there in Massachusetts. Like, I grew up on the East Coast, and I never heard of people being slaughtered by plow trucks.
For me, it was more the fact that John wouldn't leave the kids all night. Like, you know what I mean? Even if in her mind he dipped out to hit some strange,
he would have come home.
He would have still come home. When he's not answering, when there's no sign of him anywhere via any kind of form of communication, I think that the human mind just kind of goes there. You like start to panic, because I just don't think that in her mind there would be any set of circumstances where he would just not show up especially after she leaves the message. She's like, I'm fucking leaving. I'm leaving the fucking kids. Like I'm like trying to force his hand to get back to the house. And obviously she didn't leave until she did leave in the morning. But I mean, like I think in her mind, it had to have been something catastrophic in order for him not to show up. So like I don't think that's crazy. I don't think that's crazy. It's because the kids were involved, because she is not a parent to those children. She has no real obligation to be there. So I don't know.
So what I want to ask the chat is this. If you're on sitting in a civil jury, and now wipe your mind of all your feelings and everything and you've got one person putting forth this story of a woman admittedly was drunk, admittedly was driving drunk, admittedly was very close in proximity, her vehicle to that man before he died on that lawn. And they've got an expert saying the car hit the body. This all makes sense. And see, but here's the thing. If it was that Blue Man Group, I can't even convince myself, but I'm going to keep saying this anyway, because I just don't think I would find that credible under any set of circumstances, the whole Blue Man Group. But let's just say they get an expert that somehow says
it doesn't suck.
That doesn't suck.
It doesn't suck. That they get an actual expert who actually puts some evidence on that there is a way that John could have been struck by this vehicle that's not fucking patently absurd. Like that's all it takes, because as good as you have to assume that they're going to hire Wolf again and maybe Rensler. Like, I mean, if it ain't broke, don't fix it. Those guys are phenomenal. So you bring them in.
I think you bring in someone else too, just to cover
all
other
the bases,
things, all the other things. But in any event, let's just keep going. And they have their one story, and this is the way it goes down. And then you have the defense, who's putting forth a bunch of possibilities, but none of which actually can be, how much they can prove of it. It's conjecture. A lot of it's conjecture. They aren't going to be able to go, unless they're getting back into that house and digging up the ground and finding blood under there. It's conjecture. It's missing cell phones. It's suspicion. Are you going to find that it is more likely than not that he was hit by a vehicle? Because you can't find it's more likely than not this other story is true. Is the two stories, do you think the two stories in a civil case might have the same result of someone being like, well, I believe this story more? Because, the defense does have a burden. Do you think that that's a realistic possibility, that without actual evidence to back up this went down in the house thing, that a jury might be like, well, there's more evidence for the other story, the story that she hit him?
Yeah. I mean, yeah, I don't know. Like that, it's such a lower burden. It's so different than a criminal trial. And it's like, we're going to be sitting there whenever this happens, if I'm still alive when the trial goes on, we're going to be watching this thing, and it's going to feel like a criminal trial, because they're going to be litigating the same facts, but just in a much different fashion. And but man, what I want more than anything is, like, I want to be a fly on the wall in all of these depositions. I mean, that's the reason why you join all these other parties. You countersue the Tullys, the Alberts, the McCabe's, MSP, Canton PD. If you can survive summary judgment and governmental immunity with those guys, because you want to be able to conduct all these deps, but more importantly, you want to be able to get the discovery that you want, because it would be tougher to get the discovery if they're not parties in the matter.
Right.
So like they're forced to do it,
or they can get the depositions, but it would be really hard to get their cell phones. Right.
What happens if they come back after all the discovery's done in this, and they're like, they don't find any smoking gun against anybody in that house, that they were able to successfully cover it all up. You know,
I
that
think
there's
I think they almost do the same in the criminal that they did in the civil they did in the criminal. I almost think if they try too hard to say this is who did it and this is how they did it, and they don't have the smoking gun, that it might end up with a jury balancing two stories again and being like, so the you know I was trying to find somebody's comment that I just had up there and I lost it, that said, what would you use to even show a preponderance in this case? And
yeah, Travis wants to remind you they got 8 guilty votes in trial 1 with an ill-equipped MSP expert. So,
no,
and that's not just to Allie, Travis, that's to everybody. And we're talking about a preponderance of the evidence. That's the burden here. So it's much lower, but it's going to be,
I agree with a lot of what the people in the chat are saying though. Like, I just can't look at those injuries and see anything but an animal attack.
Right. And I think that we're going to, like, that's the part in this civil trial where we're going to get a hell of a lot more into, like, is the dog bite stuff. I think that there's going, like, they're not going to be able to exclude the fact that fucking Chloe was rehomed. And like all the weird things that happened are going to be fair game in the civil trial.
Right.
Like all of the things that Canoni kept out, they're coming in here. Like it's a whole different beast.
Yeah.
So it's going to be really, really, it's going to be slow.
I'd almost be thinking to let the other lawyers chime in more, like, because Alan Jackson, he's going to have his one way of thinking about it, right?
Yeah.
Now you've got all these other minds who are going to be able to look at the evidence and see some other things as well. Like, I still think that the timestamp thing on the clock and the reverse, when the reverse took place, like that whole thing, I still think there's something there that proves that their whole timeline is out of whack. I don't know.
Yeah.
I don't know.
I mean, like the shit with Aiden, it's surprising to me that they didn't.
Now, if you were Karen's lawyer, independent of Alan Jackson or anybody else, you would say, we need to bring in Turtle Boy. You would, because that he belongs in there. They are blaming her for his actions. He's a necessary party almost.
Yeah.
You'll see if any of her other lawyers are like, no, he's a necessary party. We have to sue him. And Karen Reed's going to be like, we cannot sue him. He was like, like that. That's a very interesting legal issue, because if you are the insurance company, and I don't know enough about insurance law, like, is there a time where, I mean, the insurance company could just put up their money and be like, it's cost us less to put up all this money. That's it. We're out. But if the insurance company is fighting and Karen Reed is saying, no, I don't want to sue Turtle Boy, I don't think she's got that option to say, no, I don't want to sue Turtle Boy. I think that her lawyer is going to sue any liable parties that for the conduct that she's being sued for.
Yeah. I mean, 100%. Like, I mean, your duty is to your client.
But that falls outside of what the insurance company the car insurance
I
company
just want to know who the fuck all these lawyers are, and like what is their end game here? It's like you've got Alan. I think he's the countersuit guy, right? Like he's the guy who's going to basically be a counter plaintiff.
Right, and he's going to stand by Karen's side and do whatever he can, like he's got his own motivations. Like he's in.
But I'm dying to know if this guy, like the South African sounding guy, was a guy that is an insurance defense guy.
Right. I mean, I looked up his firm. They've got, it's called Diller Law. So you're not hearing like Diller Mata, blah, 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 and blah, blah, blah. But there are a lot of lawyers that work at this firm. Like, I'm looking at a picture with, like 24 about right here,
Yeah, I don't
10, 20 lawyers at least.
I'm sure the South African lawyer can like that's the other part of this, y'all, that there so there's alleged to have been a automobile that was involved in this by the plaintiff.
Which puts the
Karen,
insurance company's
right,
money at risk.
Right. Karen puts the claim in with her insurance company. They provide you with a lawyer. So, and I look, in terms of who that defense lawyer is going to be, in terms of who the insurance company is going to put forward, it's going to depend on their downswing, their potential downswing. Because I know insurance companies will use many firms, to handle their defense work. So, I mean, if this guy is, a dude from a firm that does almost exclusively all insurance defense work, because to me, insurance defense guys are the princes of darkness. Like I like out of any lawyer on the planet that I detest the most, it's insurance defense guys, because they're literally just fucking people out of money that many times honestly need it and deserve it because they've been injured. And they'll like, oh, pre-existing condition bullshit. They have so many ways of fucking people over that deserve the money, that have been injured as a result of somebody else's negligence. And it's not that you're saying that person's a terrible person, or you're saying, look, an accident took place and it was your person's fault. And now, you're trying to screw the person that's been injured, especially with soft tissue shit.
Right.
Because every insurer, like if you were to listen to insurance defense lawyers, that shit's all fake. You're all making it up. You talk to somebody who's been in an automobile accident, hit going 50 miles an hour, rear-ended, and it's fucking jarred them to the core, and then their body's never the same. Like that.
Do we have any
little twist in
insurance
your neck.
adjusters out there in our chat here? Because what I started to say actually doesn't hold water, because I don't think that
Exactly,
the
Kathy.
insurance
Exactly.
company's lawyer would be defending the negligent infliction claim. So, but I don't know enough about personal injury defense to know, when you have those multiple claims, one that involves a vehicle and one that doesn't in the same suit, if they say to you, you have to hire your own lawyer to defend this other claim.
They
Because
might.
but think about it from a legal perspective, right? Like, just like lawyers and your duty to your clients, like if you have to come into a lawsuit, you can't only choose to defend one claim.
Right.
You know what I mean? So
Right.
I don't know. I don't know
That's
exactly
what I'm
how.
saying. Like, who the fuck are these 9 lawyers? You know what I mean? There's a lot of lawyers there.
Yeah, definitely some of those all but one, were there 2 people that spoke before Alan? Because I would suspect that they only have one who is the insurance defense guy.
Yeah, I don't know. Yeah, but that's a good point that you make in terms of like the NEID claim, and because it's not really related at all to the coverage. Now that she might be able to have
separate counsel for,
but as part of her homeowner's policy. So, I mean, because you can get coverage on your homeowner's policy that's going to be separate than from your automobile insurance coverage. And, especially
but not for an intentional act. I
maybe
know there's negligent.
they're
claim as
saying
well.
negligent. Well, that I didn't hear IIED. I heard NEID.
I did, but then one of them said there's one that was called intentional negligence / reckless / intentional, which out here, I would say, in all the states that I've practiced civil cases in, so I guess New York, Pennsylvania, New Jersey, and here, you'd have to separate those claims out. You can't put your negligent infliction claim with your intentional infliction claim. You'd have to have a separate, cause of action.
That's why we love you, Travis.
All right. So Travis was an insurance defense lawyer, coverage counsel for 11 years. All right. So Travis, if she hadn't hired any other lawyer, and you have the 2 claims, you've got, let's just say you have got a reckless driving claim and an intentional infliction of see, but it's weird because it definitely sounds like the claims involve both the intentional infliction or negligent infliction. That's why I wanted you to send me the complaint so I could look at it. They involve the actual death that came from the accident, because they definitely talked about, when they saw the bodies, how long after, blah, 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 blah. But then they're also talking about her campaign of disinformation caused emotional distress as well. So I don't know about that, but Travis, if there's one lawyer and there's two claims, and let's just say it's a separate claim, let's just talk about only the part that this, false information, which is still related to false information about the accident, would you have to, I'm assuming you would have to defend both claims if she didn't get separate lawyers. I don't know. I'm trying to keep an eye out for his thing. But what do you guys think about the backlash if her lawyer were to intervene, countersue or bring in as a necessary party Aiden? And how do you think the backlash that Karen would get from that if it were to happen? Travis says, okay, you have to defend the intentional infliction, and punitive damage is not covered because the insurer's duty to defend is broader than the duty to indemnify. Okay, so that's what I thought. Now, the follow-up question to that is, if she hires, as she did here, separate lawyers, could there be some sort of agreement or contract between Karen, her other lawyers, and the insurance company that says, we're going to handle this and we're going to hold you completely harmless for not defending it, or we want you not to be involved with it, something like that? Because, how do you deal with the issue? Like I'm saying, if the insurance company has a duty to defend that claim and they want to bring in Aiden because he's the one that they're accusing to have done the stuff, in any other lawsuit, any other situation, I am bringing in whoever the person is that they say you are responsible for this person's behavior. Always you bring in that other person. How you would deal with that issue if the client's like, wait, I don't want to sue that person. And Mandy, keep an eye out for Travis's response. I'm going to go back to the people's questions here.
The people's questions.
The people's questions.
People's court.
Colleen S13 says 50K is the minimum, I believe. Oh, you guys are talking about the threshold minimum for
there was a lot of discussion about that in the chat. They're only suing for, there's like in Illinois, we have a jurisdictional limitation in terms of like if we want
the lowest,
right? Like you have small claims court here, you have law medium, which is typically going to go to mandatory arbitration, and then you've got law division, which is the bigger trials, higher damages. So I think in Illinois, ours is 75.
Right. So if theirs is 50 in Massachusetts, that's all you have to say. You have to say in excess of $50,000.
Right.
Because that's the jurisdictional minimum. Does not by any way, shape, or form mean that's what they are actually suing for.
Right.
So there's that. Where was I?
Spooks.
Oh, Idiot Win says, wait, what? But Idiot Win's question was up there. I was going to read it.
Oh.
Well, Mandy, put it back up and we'll, bye, babe. He probably did whatever. Swiped left, swiped right. Shaboog says the bar is even. Oh, question. If Karen Reed genuinely was in panic, hey, he's back. At the time, she said the things to Kaylee, needed Jen's number, regardless of whether she killed him or not. Does putting that image in her head mean intentional infliction of emotional distress? I mean, I just, I was trying to think about and again, that was 25 years ago. So in law school, they used that he's as gay as a $3 bill example. But what I can't remember is, did the courts find that to be outrageous enough? Do you remember?
I don't think they did. I don't think that they did. I mean, because like
it has to be shocking to the conscience, extreme, outrageous conduct. Taking what they're saying, that she had a maternal relationship. She knew that this person was at high risk of emotional damage, and then woke her up.
have they brought IIED claims?
I told you, it said negligent / reckless / intentional.
Well, they're different claims.
That's what I was said, that in most states you'd have to separate those claims out and plead them each as separate counts. Oh God.
What's wrong?
My shoulder hurts.
Oh.
So I don't think so, because let's say that she, like telling her it happened, assuming like, okay, he actually was hit. How can that be extreme emotional, inflicting emotional distress by telling somebody what happened, even though it's not what happened? I'm just saying, like, all right, I'll be right back. Sorry.
All right, I'll keep going with the questions. Hopefully, Idiot Win, Allie answered your question. Let's see, where were we? I don't even see Idiot Win's question anywhere. Huh. Interesting. I think we were at Spoogs. So Allie put up Colleen. I'm not seeing Idiot Win. So Spoog says bar is low, even with a case that found her not guilty of it. Yeah, it's a civil case, Spoogs. It's just a completely different thing. It's one has nothing to do with the other. Like civil is civil. I mean, you could sue anybody in this country. I mean, you can come with some frivolous shit. Now, the penalty to that is if you bring some frivolous shit and you are found not liable, you can turn around and try to get your fees from the other party. So I mean, there's teeth. If you're going to go and do something and it doesn't work out for you, but like that, the part of this thing that I want you guys to think of constantly and this is going to take years. This is not a criminal case. There's no speedy trial demand here. It's civil judges have a different role than criminal judges in the sense that they try to keep their docket moving. They also understand that the discovery process is much more entailed in a civil case than it is in a criminal case, especially in states or commonwealths that you can't do depositions in criminal cases. Like Illinois, we can't do deps. So typically our discovery process is them being the state, turning over the police reports, recordings, videos, all that type of stuff. And then in our investigation, we'll go and try to talk with witnesses and things of that nature. Civil's a whole different beast. Like, that's why the judge was like, I'll set a spring trial date, but that's not very realistic because it's not. Like, they're like,
he kept trying. He's like, but I can do it. I can do it right now.
I think he's acutely aware of what this case is. And I think that as a good judge, I found him to be a very bright judge. And I know that he's been on the civil bench for a long time. I can tell. And he said it. I mean, the reality is that these cases settle and that people may have an idea, and he's talking to the parties. People may have an idea of what they're looking to get out of this thing, but you're soon going to find out, the likelihood is you're not going to get what you're looking for. And, there may be a way to resolve this another way, to where you get some satisfaction. So, because I don't know if you were to throw some kind of percentile on it, like what percentage of civil cases settle? I'd say like 90 plus.
Yeah, it's definitely a high number.
Like it doesn't go to trial. It's much like the criminal courts. Most cases don't go to trial. Most cases are pled out. That's just facts. I
would
know
say
that
there's definitely a lower, the more civil trials go to trial than criminal trials.
For sure.
Yeah.
Especially in accident cases. you know, and especially because like there you have the
Insurance company deciding.
defense guy. That's how they make their money. They want to litigate. They want to.
Yeah, Travis.
Yeah, Travis, 11 years, Prince of Darkness. He's come. He's seen the light though, so we have much love for Travis. So obviously, we're kidding.
Did you do Shaboogs, and thanks
I
for your
did.
continued
I
support.
did. Yeah, we love Shaboogs so much. Lindsay Bay, how much O'Keefe's seeking in damages? We don't know.
You touched on that, right?
We don't know. Yeah, I mean, we know like what you're seeing in terms of jurisdictional limits, in terms of the low end. That's all you have to say. Like Ali said, you basically throw in there in excess of whatever that jurisdictional limit is.
Right. So Pam says, will the civil trial be allowed to know the criminal jury found Karen Reed not guilty, that there was no collusion? So the answer to that is collision. Sorry. The answer
and collusion.
Right. The answer to that is no, they will not be able to know that. Because the verdict, the burden is so different, they consider it to be completely irrelevant that she wasn't able to be proven guilty beyond a reasonable doubt.
Right.
Thank you, Lynette. We appreciate that.
Always.
Cat Toes. Can Karen bring a wrongful death suit against the McAlberts? No, she is not his next of kin. If they were married, then she would. Also, are the O'Keefes out of pocket for their attorneys? Bob and I are wondering the very same thing. We kind of talked about that. I would suspect that like Bob said, it's typical that it's a contingency. Yeah. If this came to me, I'd be saying, look, I'll take it, but I need you guys to
hybrid, maybe some kind of
hybrid thing where you're paying some of the costs, because the costs are going to be astronomical.
Oh God. It's like
astronomical.
Jesus. Like on average, to do a deposition, if it's a 6-hour dep, it's going to run you about $2,000.
We had a civil case that lasted at least way more than that. That would be a short dep.
Are you talking? Well, yeah, that's like a 6
That's without getting the transcript, I guess.
Right.
Just the lawyers. Right. Okay.
Right.
So we did a civil case that for, I think it was like 3-4 years. And we got our client we can't say, well, if I don't say what it is, $1.5 million. And the defense attorney told me he still made out the best.
Yeah, they made more money.
So
because they fought it. And that was in federal court. You know, in federal court, much like on the criminal side, they try to move it along.
Right.
Move it along. You know, so this is state court. You know, I'm just trying to warn everybody that these, like, the next date's going to be much ado about nothing. Like, we'll cover it, but you know,
right.
I don't want everybody getting all excited.
I'm sure they'll have filed their motion,
right,
and they'll be going in to get dates.
It could be interesting if they've sought to file their counterclaims.
I think that they will have them filed by then, and then it'll be a matter of either the plaintiff still needing time to respond and then setting a briefing schedule and then a hearing date. But we're not going to hear, I doubt we would hear anything actually substantive about it.
Yeah.
Sleepless Sleuth. Dram Shop, wouldn't that only be the waterfall? I mean, they've got the waterfall, McCarthy's, and I think
she drank more at McCarthy's, at least allegedly. You know, that's where she did the 9 shots. So I don't, it's like,
but they've got
when you look at her though, she didn't look overserved from like the videos we saw at McCarthy's. You know, she wasn't falling down drunk. You know, she just wasn't. So
CC Hospitality is an entity that owns McCarthy's, as is G&S Hospitality. They're both DBAs of McCarthy's. Then you've got the Waterfall, and then you've got Karen. So
what did so Mama GS, would you please answer about the 1983? I'm assuming that's the civil rights claim.
Yeah, I thought that lawyer, that the plaintiffs, the defense lawyer, was correct when he said that not all 1983 claims, you don't have to bring them in federal court. There is a state avenue for it. So it sounds like the plaintiff was concerned that they may try to, which the plaintiff could, if they wanted to, remove it to federal court. And then if the 1983 claim, which is a civil rights claim, that's what 1983 is. It's a civil rights claim. Then it would go back to state court. But it sounded like that if they are raising those claims that they intend to stay in state court, because he said that it would go in state court. But I don't think that's for the judge to even be concerned with, whether or not it would have to get moved to either they have the right to bring it or she doesn't.
Right.
As part of the same operative facts. Live Free 7. Larry DUI guy did an interview with who's that?
Segelson?
Is that the lawyer?
I'm Seligson. Yeah, I'm assuming that Live Free, is that the South African guy? Is that the dude? I'm assuming, but I could be wrong. So let me know in chat.
And thank you. Adrian.
Yep.
Scottish Cordy. Guys, question. In a civil case, can they plead the fifth? She can't plead the fifth because she's been found not guilty. So she is not eligible. Has no risk.
There's no hiding.
Right.
There's no hiding in a civil. That's
so you could if you had not been found not guilty in a criminal case, then sure, you could plead the fifth in a civil case.
Like the Proctors of the world. Like if he had some kind of potential criminal liability, seeing as he's never been charged criminally, and neither is Buchanan or any of those guys. If they were asked a question which could trigger criminal liability, they could plead the fifth if they wanted to in a deposition. But Karen, she's been fully adjudicated on the criminal side. There's no coming back at her on the criminal side. So, again, this is all just about money. That's what civil cases are. It's all cash. So, and it's good to see you over here, Adrian. Adrian loves Court TV. She's always trumpeting appearances on Court TV. So we love you over here.
Idiot Win gifted 10 DD memberships. Thank you very much.
Thank you. All those family hugs. Oh, family hug. Okay, so Nicole Kelly, are you able to sue Lally and Hank?
I sure as fuck would. Just for the introduction of that damn inverted video. I would want to, and I'd try to figure out a way to.
Oh, man.
Yeah, that would be in their roles as prosecutors. There would be a lot of
not a chance.
There's immunity for your prosecutorial decisions. So I probably think the answer is no, that you cannot sue Lally and Hank. But Lally,
I'd rather go after Morrissey anyway. He's the fucking guy.
Oh yeah, that's never happening. You cannot be sued for your prosecutorial decisions.
Yeah.
So
it's like they're basically bulletproof. It's like one of the many things that I don't like about prosecutors. So but thank you, Nicole. Pulley Mom, member for 13 months. Oh, thank you so much. Congrats on the Bears win. It is Victory Monday over here. I am glowing in the bask of winning a football game. Finally. I told Allie today, it had been since last October.
I mentioned that.
Last October since the Bears had won a home game. So
I didn't
as you can imagine, as a season ticket holder, that's a lot of going to the game, going through the trouble of tailgating, parking, getting out of the stadium, doing all that work.
Bob used to get up so early.
Oh God.
The crack of dawn, piling up the car with all the stuff for the cooking and the sitting and the hanging and the doing. And then there were all those days of drinking.
Yeah. And coming home and sleeping on the couch.
I used to just want to put the score on just so I could know, is Bob going to be in a good mood? I want my dad to be in a good mood. He takes his losses much, much easier now that he's not drinking.
It's true. It's true. It's true. It's just another one of the many, many benefits of quitting drinking. But yeah, thanks for that, Pulley Mom. It was I was so excited last night. I couldn't fall asleep. Like Allie.
I don't want to mean sorry.
You woke up or intermittently, and you're kind of like, what the fuck is this guy doing? I was laying there on Twitter. I must have watched the Ben Johnson locker room clip I don't know, 10 million times. I love it so much. I love it so much that I'm going to show it today as one of our final acts.
Well, then you better get to it because we're about to be done. Sky Goddess, thank you for your super sticker.
Yeah.
While you're pulling that up, I just want to talk about, like there's this app, Waste Not, Want Not. And it's that you can get, like, if you've got a big family or you just want, you just want a discount or you want to get something special, they get food from like restaurants, bakeries, that you can get like pennies on the dollar, towards the end of the day or whatever. And right now it's like really got a lot of places in Illinois. And I just had a friend that picked up like a ton of these like delicious cupcakes from like one of those like really fancy cupcake places. And she got them like super, super cheap. So if you're in Illinois, you should definitely download the app no matter where you're at. If getting discounts on really good food is your thing.
Yeah,
and
if you're tight on cash,
right.
It's
Or
amazing.
it's like you just want to get the family something that, like indulging in a ton of those kind of cupcakes.
Goodies.
Is like expensive as shit and a bunch of bakery stuff. But
Yeah, because
and
like
as
the upscale like cookie and cupcake places are not cheap.
No,
They're just
no,
not.
But if you download the app and they get more as they grow into more states, you'll get notice about it. But there's a lot of places in the Chicagoland and Illinois area now.
Yeah, and then so for tomorrow evening, and I'm always so disappointed because I get such small crowds for the wrongfully convicted work that we do over here at Defense Diaries. I'm inviting Dr. Nikki Jackson back and Timmy, who were here, who was in prison for 24 years for a crime he did not commit. Just an unbelievable guy. So they're coming back tomorrow evening. Allie and I might do something during the day. We have an awful lot of Richard Allen newly minted discovery or evidence that came out late last week that we're trying to dig through. We certainly want to cover that. And we also still intend on covering Federo's massive mega motion. So those are two things that early.
Wait, did you mention? I'm sorry because I was totally spacing. Did you mention Richard Allen?
I did.
Okay.
Yes, we will definitely be covering Richard Allen.
Bob and I were we were both in tears.
I was
the
crying.
other night in bed. Like it was.
I'm a crybaby though.
Yeah, but I was crying too. So
yeah, you're not as much of a crybaby as I am.
Well, it's just different things I think that make us cry. I'm definitely a crybaby as well, but
I'm a crybaby.
Are you bringing up this thing that you want to discuss?
I am. So, all right, here, let me pull it over here. And
I thought I was going to sneeze again.
So I must have watched this, I don't know, 500 times last night. Because if you're a Bears fan and you've just been going through it for as long as I have, and it's like, and I give a shit. I wish I didn't. Like, I wish I didn't care. I'm like, I'm a grown man. It's like, why am I acting like a child? Why do I give a shit so much? Like, it affects my mood so much. And it's really all of Chicago. Like, walking out of that stadium game after game, just like feeling enraged and depressed is so fucking horrible. So yeah, this thing that went down yesterday is just delicious. It was I'm so excited about our new head coach, Ben Johnson, that this thing just really touched the cockles of my heart. So let me bring it up so that you guys can see what's up. All right. So this is post game in the Bears locker room. This is young number 18, Caleb Williams, our new quarterback, who takes so much shit online. Like I fucking love this kid. I think he's going to be the first great quarterback that the oldest franchise in the NFL has ever had. First one ever. Like, Jim McMahon was fine. He wasn't a great quarterback. Didn't play for that long. And we talk about some dude named Sid Luckman, who was before my time. So for the oldest franchise to never even fall accidentally into a good quarterback is insane. So this is the post game, and this is after Caleb got a game ball, and it's just worthwhile.
Hell yeah, keep going.
Yeah, so I watched that a million times last night. It like today, it still gave me goosebumps. I'm like, I'm not over it. I'm not over it. So
I'm so happy for you, babe.
Thank you, my love. You're so sweet. Like we were talking about how sweet you are. We were talking about that thing, like Cam. We went out to eat because I brought the kids yesterday, and Allie doesn't really care about football that much at all.
I would have, if there was an extra ticket, I would have loved to go just because you had all the kids. But
yeah,
I don't. If 3 tickets, I would want the 3 extras to go to our 3 children over me every time.
Well, and Courtney, our oldest, doesn't give a shit about football either. Like she cares maybe less than Allie. Yeah, plus she's in Florida. That too. But even if she was home, like she wouldn't be like, she'd be like, I'm good. But yeah, that was but so we were talking about you, and Cam's like, Mom's so cute. She's like, she will like sit there, like knowing you're at the game, and like even after drinking, like after the drinking days, like when like in the last 5 years, like you'll put the game on and you'll play like video poker or do whatever the hell you're doing. And, just to kind of keep an eye on it, just to be like, oh, is Bob going to be happy? Is this a good day for Bob? And she's like, it's so sweet. You are so sweet.
Yeah. And I mean, that is just because I want you to have the happiness that you feel right now, not because I'm worried that you're going to be in an awful mood. And I don't mean to make it sound like you were like a raging lunatic, but it just puts you in a better.
Yeah, like a shit mood. It fucking sucks, man. And they've only won 1 game. That's the ironic thing about it, but it feels like they won the Super Bowl. Like that's how pathetic it is. Idiot Win came back with another 10 DD podcast memberships. Thank you so much always for your wonderful support, Idiot Win. We adore you so much. And then Bobby Costa, you get a family hug. We love you. Thank you for becoming a member. Yes. And by the way, become a member. We love having our members. We finally did our members only last week. I think I've changed it to allow. It was on Wendy. Because I was kind of like, I was over Donna, and I know everybody wants to go after Wendy. So Allie and I spent some time figuring out whether or not they have enough to go after her, and at the end of that live we tell you whether or not we think so. And I may have changed my tune on that because I was very adamant that I didn't think that they had enough, and then after Donna's I might have in fact changed my tune, so go check that out. But please remember to like, share, and subscribe to the channel. We're right on the verge of finally crossing over 57
Hey, new Jen and Toxic.
Jen and Toxic, which I love your handle, by the way. Family hug for you. So, all right, y'all. Again, keep your eye out for the wrongful conviction stuff that we'll be doing tomorrow night. And like, if you claim that you care about the judicial system and the criminal justice system, come and watch it. These stories are unbelievable. It's like, it's beyond like the 5 cases that you may follow. Kind of take an interest in some of the other stuff. These stories will just pull at your heartstrings, and they're unbelievable. They're sad, but they're also so enlightening. And at the end of the day, you come away from these things when I have these folks on just feeling like, wow, that's like an amazing person. Like to a person, every single one of these wrongfully convicted people that I've had on, you kind of walk away feeling like, man, that's like, I don't know how they do that. Like, I'd be so pissed off if 25 of my years was spent in a prison for a crime I didn't commit. I'd be one bitter, angry mofo. And like, none of these people are that I've had on. So it'd be worth your time. I think you guys will take something from it, maybe learn something, which is always the goal over here. So, all right, y'all, we love you so much. Mods, thank you so much. Mandy, Tracy, we adore you. We absolutely couldn't do it without you. Thank you for working with Allie yesterday to get the setup for today, giving me a full day of just Bears glory. Plus the Packers lost. It was just an all around great day. So we love you guys. Thank you, because without you, I am just an old man
sitting around watching Bears posts.
Yeah, Bear.